This is the defamation and privacy torts audio outline. Note, there are two types of defamation. The first is common law defamation. The second is First Amendment defamation. Common law defamation. There are 4 elements of a common law defamation claim. 1. Defamatory language. 2. Of or concerning the plaintiff. 3. Published by the defendant to a third party. 4. Damage to the plaintiff's reputation. First Amendment defamation. There are 6 elements to First Amendment defamation. The first 4 elements are the same as common law defamation claim. The last 2 elements include number 5, falsity of the defamatory language, and 6, fault on the part of the defendant. Element 1, defamatory language, must be something that could adversely affect the plaintiff's reputation. Opinion is not enough unless it appears based on specific facts or allegations. There are no defamation claims for deceased persons. Element 2, of or concerning the plaintiff. If a reasonable listener, reader, or viewer would not know who the statement was regarding, this element is not met. An additional related issue here is group defamation. Group defamation. Note, groups can bring a lawsuit if it is a small group of about 15 people and there is a defamatory statement about all members of that group. If the statement is about a large group, no one person of that group can prove that it is about them. If the statement is about some members of a small group, then the plaintiff may be able to show that a reasonable person could view that statement is about them. Element 3, publication. Do not interpret this literally. Publication simply means written or spoken so that a third party reads or hears it. It can be an intentional publication or negligent publication. For example, someone walking down the hall hears a private conversation. Those statements are published to the person walking down the hall. Element 4, damage to the plaintiff's reputation. Varies depending on what type of defamation it is. Types of defamation are slander, which is spoken, slander per se, and libel, which is printed. When defamation is of the libel type, general damages are presumed. The plaintiff does not have to prove special damages. Note, because it is in writing, it is easier to get more damages. Slander per se is treated the same as libel. Defamation that is slander, the plaintiff must prove special damages. Slander per se. Slander per se falls into 4 categories. Note, because of these categories, they are treated as more severe. Category 1 for slander per se is when one is or was guilty of a crime of moral turpitude. The second category of statements for slander per se is one has a loathsome disease. The third category of statements include adversely reflecting on one's conduct in a business or profession. And the fourth category includes a woman is unchaste. First Amendment defamation. This applies where it is a matter of public concern. A matter of public concern, this element could be debatable. Does it affect the community, or is it purely a private matter? Note, First Amendment defamation and constitutional defamation are the same thing. Element 5, falsity. Plaintiff must prove the falsity of a statement. This element is for First Amendment defamation only. Element 6, fault on the part of the defendant. Plaintiff must prove fault. The level of fault will depend on the plaintiff's status. Is the plaintiff a public figure or a private individual? Public figures or public officials, the plaintiff must prove malice on the part of the defendant. For private individuals, the plaintiff must prove negligence. Please note, this is a lower standard of proof. What is a public figure? A public figure is someone who achieves fame or notoriety. Please note, a limited public figure voluntarily assumes a central role in a public controversy. Please note, a public official is sworn in to perform a duty for the public. Malice requirement. Under New York Times versus Sullivan, malice must be proved in First Amendment defamation cases brought by public figures or public officials. Malice is 1. Knowledge that the statement was false, or 2. Reckless disregard as to whether it was false. Remember, private persons do not need to prove malice. Please note, on the LWA exam, please be sure to list the name of this case as well as the first 2 bullets of the black letter law. Level of fault. If it is a matter of public concern and the plaintiff is a public official or public figure, malice must be proved. If it is a matter of public concern and the plaintiff is a private figure, negligence must be proved. If it is a private matter and a private individual, don't address this element. This is a common law defamation case. Please note, common law defamation only has 4 elements. Defenses to defamation include 1. Consent. 2. Truth. 3. Absolute privileges. Please note, they include executive, judicial, and legislative privileges. And 4, the 4th defense to defamation is qualified privileges. Please note, they include statements made to protect the interests of a self, others, or a group. Please note, exceeding the scope makes any of these defenses invalid. Also can be lost with excessive publication or with malice. Exam tip for First Amendment defamation. If it is a matter of public concern, but you cannot prove element 5 because the statement is actually true, consider whether a claim for intentional infliction of emotional distress or a privacy tort can be raised instead. Please note, have a backup claim. Privacy torts. There are 4 types of main privacy torts. Number 1, appropriation of the plaintiff's picture or name. 2, intrusion upon the plaintiff's affairs or seclusion. 3, publication of facts placing the plaintiff in a false light. Number 4, public disclosure of private facts about the plaintiff. Appropriation. Unauthorized use of the plaintiff's name or likeness for the defendant's commercial advantage. Please note, companies cannot use anyone's likeness for financial gain without authorization. Please note, there must be financial gain in order to meet this element. Intrusion. Prying or intruding that would be objectionable to a reasonable person. Plaintiff must be in a place of privacy. There are no intrusion actions for things done in public. False light. False light must be something objectionable to a reasonable person under the circumstances. This is broader than defamation. Please note, could be used if there is no defamation if it is true, because false light is simply objectionable under the circumstances. Public disclosure of private facts. Information must be private and disclosure must be objectionable to a reasonable person. Note, examples are academic records, medical records, and financial statements. Causation. For all privacy actions, the invasion upon the plaintiff's privacy must have been proximately caused by the defendant's conduct. Damages. There is no requirement to prove special damages. Emotional distress and mental anguish are sufficient damages for invasion to privacy actions. Defenses. Defenses for privacy torts include consent and privileges of defamation law, absolute and qualified. They apply where applicable. This concludes the defamation and privacy torts audio outline.